to try to speak for about 30 to 40 minutes and then have 20 minutes of question and answer at the end. There's going to be a chat function, and Donna, if you'd like, maybe you can describe the chat function to all of the attendees.
So the chat function is actually turned off, but we have the Q&A button at the bottom to answer all your questions.
Great. We've got other attorneys on, and as you're sending in your question, we're going to respond to it privately. So we're going to try to get to all of them. We've done one prior town hall. We had really so many questions coming in in a rapid succession that we weren't able to all of them. So if you ask a question and you're not able to get an answer, we invite you to, at the very end, we're going to give you email address and a telephone number to call so you can get an answer from either one of our staff or one of our attorneys. If it's a legal question, one of the attorneys will answer it. But do send in questions as we're talking. It is helpful to kind of get a sense of what questions are remain unanswered. And then, sort of at the very end, we'll describe, upcoming town halls or give you the dates of upcoming town halls. They're all fairly uniform, so you should see, if you attend a future one, a presentation much like the one that you're going to get today. But we invite you to attend a future one as you see fit. So I think it's now 2 minutes after our appointed time, so I'll just continue to talk again. My name is Douglas Priest, one of the partners here at Elsteck, Priest and Overholtz. I've got with me Brad Bradford, who's going to speak, Jennifer Hoekstra, and Dan Thornburg. All three of them are, partners here, but they're litigation partners in that they've been integral parts of the national litigation. We'll talk about the 16 trials that have transpired thus far in what's called a bellwether process. But each one of the three attorneys that you're going to hear from have participated as either lead trial counsel or second chair, meaning they put on our own witnesses, cross 3M's own witnesses. And so I think you've got a really great panel today. A little bit about our firm. We are just over 21 attorneys, over 200 staff. Prior to the 3M litigation, we had around 120 staff. We have increased our staff over 200. Most of those are service members, I should say. A couple of them are active service members who are in reserve. Most of them are veterans. Donna Law, who you see on your screen, was in the Army. She's a veteran. She was Army intelligence. She came on board as our human resource officer before the 3M litigation started. And so it just happened to be that we lucked out having Donna. And so she's been vital in getting us, increasing our staff to include veterans. And those veterans are here for you. So I want, to the extent that, we represent, by the way, over 40,000 clients in what is around 250,000 national clients. So we have about 20% of the entire inventory. And we'll talk about all of the resources we've thrown, we've poured into the case, both time and money and man and women power and so forth. But it was important for us to lean on Donna to increase our staff to include veterans who would be able to speak to our veteran clients and know all of the military acronyms but have that experience and be able to talk with some level of authority. So that's our firm. I mentioned just briefly, we are lead counsel for the entire MDL or multi-district litigation that's pending in federal court. Judge Rogers, Casey Rogers, is down the street here in Pensacola. She's an Article 3 federal judge, and she was assigned or appointed as the trial judge to oversee all of the 3M litigation nationally. So all of the cases that were filed were funneled, consolidated, and coordinated for her. She interviewed 50 lawyers, interviewed all of us, and she then appointed a slate or a body of attorneys to act as the plaintiff's steering committee. In that process, she appointed our office, our law firm, to be lead counsel, specifically our partner Brian Elstock to be the lead lawyer and the one in charge of marshaling all of the resources and working with other counsel and coordinating the entire litigation. That's what's happened over the last 3 years. I'm going to ask Donna in a second to open a PowerPoint, but I want you to, when we talk about 3M, we also mean a subsidiary called AWKO. And it's important, there'll be a lot of reference to this later, but in 2008, kind of in midstream in the sale of this product to the DoD, the product being the dual-ended combat arms version 2, midstream around 2008, AWKO sold its hearing protection business, which included the combat arms version 2 that you used, to 3M. 3M basically became the parent or the umbrella under which this product was sold from 2008 to 2015, up to actually 2016. So it's important to know that as we sit here today, there are really 2 entities, AWKO, the subsidiary of 3M, and we have sued both of them on all of our clients' cases. We're pursuing both entities. But procedurally, Jen Hoekstra in particular later will talk about why there's a distinction between the 2 parties and why that's important. So Donna, if you can pull up the PowerPoint for us. You may already have it up. Let's see if I can see it. Okay, thank you. We'll go to the next screen. All right, so here's what I was talking about. 3M is the overarching parent to AWKO. Back, if you guys have some knowledge of hearing protection, you may know the name Cabot. Cabot was the company that came up with the yellow foamy that's still been sold today. So Cabot became EAR, which became AWKO, which became 3M. And we're currently suing 3M and AWKO. Next slide. So I'm going to have Donna click through some slides very briefly, just so that we can orient ourselves on what is the claim that we're making on your behalf. So you'll recognize the combat arms dual-ended product. It is a design that never existed before it came to market in 1999, and it has never existed since its removal from the market in 2015, and I don't believe we'll ever see it again. It was a unique design, to say the least, but you'll remember there are 2 ends, the yellow and the green end. The yellow end had a hole in it, and the arrow is pointed, the red arrow in this slide is the sound that's passing through the adapter, through the filter in the middle of the 2 flanges. And that sound then goes through the yellow end that has a hole in it. And the idea was that the yellow end, you could have that in for combat, for rifle fire, and it would start protecting you at about 110 decibels. An AR-15 starts around 158 to 162 decibels. An IED obviously is variable, but an IED might be anywhere from 160 to 190 decibels. And so this plug was promised to protect you for range work, for active live fire, for mortar rounds, for using a howitzer, for IED exposure, for all of those things. And the idea that was sold to the DoD was that if you had the yellow in your ear, the camouflage out, that would allow you to not only be protected from those impulse sounds, but also be able to communicate and have better quote unquote situational awareness. The other end was the green end in and the yellow out. Of course, the yellow would be would stick out pretty noticeably, was more for continuous noise, maybe behind the wire or domestically around if you were doing transport, being in a helicopter, doing long range transport, maybe you were in a striker vehicle or whatever you were riding in, that for a long period of time you may have that in. And of course, there are all sorts of variations where the plug was used with muffs over the ears, with communication headsets and so forth. But in any event, this became the plug used for nearly all deploying soldiers during the war on terror. And so it was ubiquitous. It was everywhere within the, and of course, you can't mistake the wonky design and the look at it, the bottom below. Next slide for me, Don. So what is this case about? What's the defect really quick? Well, you'll see the white adapter stem. So this is one that's taken apart. You'll see on the left side is the green, the closed end that would be put in your ear for continuous noise. That's the closed end. Yellow is on the right with the hole in it. So you'll see the adapter stem, which is sort of this opaque looking white piece that sticks the 2 together. It's what we call the adapter or the stem or adapter stem. It is made of Delaware, which is a hard plastic, as hard as ball bearings, does not bend at all. And every one of our ears has some early curvature when you go into that ear canal. It's called the aperture. When you get right into the ear canal, everybody's ear canal has a turn, and actually a kind of an S twist. This does not accommodate any S twist, any turns at all, because it's hard as a rock, and it's stiff, and it's the other part of this the stem that was a failure is that it's too thick for ear canals. And so not only is it incompatible with the twist of the ear canal, but literature has shown, and a lot of the testing has shown, that it is too thick for the average ear canal size, and so it pushes it out from inside to out, and a push out effect. Next slide. So this is just a depiction of what they knew before it came to market in 1999 was that 4.2 millimeters of that stem is too fat. And then what they do, they made it too fat. They made it much fatter at 4.45. Next slide. So the other defect, which we'll get to, which is the opposing flanges, came to light when they were doing they finally did their noise reduction rating testing. If you go to the store today, you may be familiar with what's called an NRR, noise reduction rating. That's in the back of every single, especially in the back of every package, pursuant to EPA rule. And it has a number. That number is supposed to tell you, on average, how much reduction of how much attenuation or reduction of decibels you're supposed to get. Next slide. When they did this EPA mandatory testing, where you're supposed to do 10 subjects, they actually stopped at 8. They were trying to shoot for a 22, which in a striker vehicle, if it's at 107 decibels, 22 would reduce you down to about 85 decibels, which is sort of where you want to be under EPA guidelines, meaning around 85 or less, you don't need hearing protection for 8 hours a day. Striker vehicles, Humvees, so forth, especially if you're driving on pavement, it's loud. Certainly being in helicopters and so forth is much louder than 85 decibels. And so they knew the DoD wanted a 22 noise reduction rating on this package. They did the test at 8 subjects. You can see here, it's probably too small. The noise reduction rating they were getting is a 10.9, or let's round it to 11. I'm not going to get too technical, but 11 is not half of 22 logarithmically when we're talking about hearing protection, because it's done in multiples logarithmically. Let's just suffice it to say that it was basically 10% of the attenuation or efficacy, or 10% of the safety that the DoD would have been looking for. So they knew they could not sell an earplug with a 10.9 or an 11 NRR. Next slide. So what they did is they stopped that test against the law. They went and retested it. They manually manipulated the plug. And we got, in this discovery, we got actually the lab notebook. And the lab notebook, and you can't read it there, but basically this is a slide that depicts the experimenter in real time who was documenting this second test. They're only supposed to test it once under law, but they actually hid that test. They retested it without telling the EPA or the DoD, and when they retested it, 3 of the subjects had very poor outcomes. They logged it in a lab notebook, hand wrote the notes here, yet on the left-hand side of your screen, it's actually very small, but that's the final test results. And those test results show that it had a pristine seal and perfect attenuation through all 10 subjects, which is impossible because we already know the lab notebook told us that the product was not working properly for at least 3 of them, which would have affected the noise reduction rating tremendously. Next slide. So the great thing about this litigation is we got this thing called the Flange Report. It reads like a John Grisham novel. It's 5 pages. It's actually 1 page. It tells the whole story. The whole story being in real time, in 2000, their own lab technician and the head of the lab, a guy named Elliot Berger, expressly documented what they found to be the defects. Number 1, it didn't fit in the average ear canal, which is what we talked about earlier regarding the stem itself being too thick. Okay. They actually found that the opposing flanges, remember it's dual-ended, that this opposing flange, when you put it in the ear, actually stuck up against the exterior part of people's ear, the outer ear, and that pulled the product out of the ear imperceptibly, meaning the subjects in that lab setting didn't know the thing was loosening, just like you guys didn't know the thing was loosening, and so therefore you were getting a lack of attenuation. You might as well have had nothing in your ear, as later studies have shown, and our experts have testified on this. So this John Grisham-esque novel of 1 page with 4 test pages behind it is the smoking gun that we got in this case at the very commencement of the case. And this is something they've been trying to run from throughout the entire case. So those are the two defects of the product in terms of how it was designed. Next slide. And this is the timeline. I know a lot of folks like timelines. Left side is when they first started to sell it. The flange report documents the testing was done in 2000. They hid the results. They never provided anybody with the flange report. They hid results for 15 years. It finally came out in some ancillary different litigation that was commenced by them against a company called Moldex when they were trying to enforce a patent fraudulently, and they were caught red-handed, and the case was thrown out of court. And one of the things that came out of this litigation that they commenced in a patent case was actually the flange report that they had hidden for 15 years. And so we wouldn't be here today if it weren't for 3M and they're trying to be bullies against a smaller company, Moldex, that resulted in the production of this one document, smoking gun. Let me, I'm going to turn it, now this is a good segue, time for me to turn it over to Bradford, who's been lead trial counsel, was lead trial counsel in two of the largest verdicts to date. Brad, if you want to take it from here and kind of give us a little bit of trial history.
Thanks, Doug. I appreciate that, and I'll try to move through pretty quickly. I know it's getting close to dinner time for a lot of people, and it's getting late in the day. But there have been 16 trials over the course of this litigation. Our firm has been involved in all of them. We've been lead trial counsel in several, and in those, the plaintiffs have won 10 trials of the 16. And a couple of those had multiple plaintiffs. So 13 of 19 verdicts have been won by the plaintiff. What we found that the jury has been moved by in our cases that we've been lead on is we've had soldiers a lot like yourselves who've had noble and good service and have injuries, hearing loss and tinnitus that were caused by the earplug. And we've been able to show that through our expert testimony. For those of you who are earlier in this process that Ms. Hoekstra will talk about in a minute, you'll know that there's an involvement level that gets heightened. You have to go see doctors and do certain things. But we've had the good fortune of having wonderful and strong and noble soldiers who've been able to tell their story, and it's really resonated well with the juries. The juries don't like what 3M did here, as Mr. Crease went through. As Doug went through there, they don't like their conduct and they don't like what they did. I'm going to pass over a little bit of some of the liability story on that. But what we really need from you guys right now, the trial results have been very successful. There's a bankruptcy that has been filed that Ms. Hoekstra is going to talk about. And, we don't know where that's going to wash out. There's a lot of potential options and it's moving very quickly. It just happened a couple of weeks ago, and there are some significant hearings coming up, coming up early next week on that. But what we need from you, just like the soldiers who've had their cases tried and the ones who have been included in the early waves, is we need your participation and we need your help, because some of these deadlines, look at my cat jumping up. Some of these deadlines are fast. And 3M is betting and counting that you're not going to continue to fight and you're not going to stand up and get us what we need for the judge, for Judge Rogers to keep things moving. And if this bankruptcy, even in the short term, works for them, there's going to be a lot more filings and a lot more information that's going to be required from you ladies and gentlemen to keep your case going. So I know sometimes you may get bothered by us contacting you, and you may get bothered by the tight time frames that come with it. But what we need to do is just keep your nose down, stay with us. We're working hard. We spent tons of time and money trying these cases, and just stay with us and keep working and get us what we need, because this earplug is no good. It's harmed tens and hundreds of thousands of soldiers. I'm sure there are injured soldiers right now who aren't involved in this process for whatever reason. And just stay with us, keep working with us, get us what we need. There's going to be additional forms, additional information that we're going to have and we're going to have to get from you, because we have to have your active participation. So if we text you, if we email you, if we call you, work with us. I know it can be annoying. I know it can be pushy. I know the time frames are tight, and there's a lot of questions you have, where's the settlement, what's going on, what's happening with this bankruptcy. If I had a crystal ball and I could tell you what was happening and how this was going to work out, I would, I probably wouldn't be a lawyer. I'd be picking football games or something for a living. But Ms. Hoekstra is going to talk to you about the process specifically with bankruptcy and what we need. But again, we are honored to represent you guys. We are honored to have tried cases for your colleagues. Juries have listened to what's happened to you, and juries have understood in large part what this company did and why it's not how life should have been to have hearing loss and ringing in your ears the way you guys have been experiencing. So I'm going to hand it over to Ms. Hoekstra to talk more about the procedure.
Good evening, everybody. I just wanted to say hello. We really enjoyed representing you all for the last couple of years. Sounds awful to say considering how significant most of your impacts are, but it's been a pleasure to work with all of you and work up your cases. As most of you are aware, on the 26th of July, 3M took a fairly drastic shift in their attitude towards this litigation. For the last 3 years, every time we've gone in court, 3M is the same as AWKO. 3M has all the liability. AWKO doesn't exist anymore. All of the AWKO employees now work for 3M. It's been a pretty consistent, theme throughout the litigation that 3M is the same as AWKO. AWKO is the same as 3M. We use the documents interchangeably. But leading up from the end of the 16 trials last spring, there was court-ordered mediation. And as part of that court-ordered mediation, a large group of attorneys, defense counsel, individuals from 3M corporate sat down and discussed the merits of litigation, what to occur, and were unable to come to any sort of resolution, essentially. And within 72 hours of that, discussion not progressing, 3M basically AWKO has filed what a lot of people are calling the Hoosier Hop, which is they've essentially put some lesser 3M companies and the prior companies, AWKO, into bankruptcy in the Southern District of Indiana. Basically what happens as soon as there's a bankruptcy filing, there's an immediate stay in all litigation. It makes sense if you think about it from a company's perspective. They don't need to keep sending money out the door when they have creditors that they may not be able to pay. The interesting thing about what happened here is that it appears to be very attorney and corporate driven. They did not put 3M into bankruptcy, but expected that stay would apply to 3M. So there's been a lot of legal maneuvering the last couple of weeks. Normally what happens when a bankruptcy is filed is a temporary restraining order, or a TRO, goes out almost immediately and ceases and desists all legal activity against the company. We were able to go in front of the bankruptcy judge in Indiana within 24 hours of the bankruptcy being filed and convinced the judge that there shouldn't be a TRO, that 3M was not a debtor, that it was very obvious that the parent company had funds and they could, in all honesty, there was something else going on here that required a little bit more coordination between the parties and cooperation. We did agree, as many of you might be aware, to a voluntary slowdown. So discovery is essentially paused for a couple of weeks while the next steps in the bankruptcy are worked out. In all honesty, if defendants had come to us 3 weeks ago and said, hey, this is getting overwhelming, could we pause discovery so we can have a more fruitful negotiation, we probably would have.
Jen, I'm sorry to interrupt you, but the mic is cutting in and out.
My mic is bad?
Yeah, see if you can get a little closer. I apologize.
No, it's okay. And I guess the next step in terms of the bankruptcy, at least, is that there is a preliminary injunction hearing next Monday and Tuesday in front of the bankruptcy judge in Indianapolis. And we've been working on discovery to figure out how the relationship between AWKO and 3M changed so suddenly, how AWKO now holds all of the liability for the earplugs and 3M holds all the money, and what the next steps are in terms of an injunction that might happen in the bankruptcy. If there is any sort of shutdown of the bankruptcy, it would obviously trickle down to 3M. There's some concerns there on many levels on what the actual impact might be. Could we dismiss AWKO from all of the cases and move forward against 3M? Those are all things that are being discussed and argued in front of the courts. But at the moment, litigation is kind of in pause, and the next step becomes, do the claims go into bankruptcy for resolution? Do some of them, because people had earplugs after 2008 when 3M acquired, get to go forward in the MDL? Like, what actually happens? How does this impact individual claims? It sounds awful to say that, we don't know what the next step is, but our biggest thing from our perspective is that we need all of you to still remain engaged. If we're reaching out for information, it's impacting the bankruptcy. If we're reaching out because there's information that we need, it's because we're trying to get an accurate number of claimants for the settlement discussions. And there's a lot of unknowns on where the next step is going to be, but there's also a lot of positives. The same attorneys who've been running the litigation for the last 3 years fairly successfully have all come together and have managed to coordinate in the bankruptcy. We have, bankruptcy counsel who joined us, but we've also managed to get some additional coordination going, some additional discovery. There were 2 depositions that happened in the bankruptcy today. There's another 4 tomorrow. It'll be a full hearing, 2 days full of witnesses and testimony and evidence presented to flesh out this relationship between 3M and AWKO, all of which, in all honesty, will help all of our clients as this process proceeds. In terms of what the next step is, we may not know further information until after the hearing next week, but we're going to, continue being involved and continuing reaching out as information happens. Jan, I didn't know if you wanted to go on further.
Yeah, I can talk a little bit about, just the importance, I think, for you all to continue to hold on to any evidence that you have. Evidence will become very important, especially if, your case at some future time gets selected for trial. So please, if you've got pictures of yourselves, in theater or wearing uniform or wearing the combat arms earplugs, continue to preserve those. Continue to preserve, if you have the earplugs, preserve those, keep those in your possession. Don't destroy any potential evidence that could be used either as evidence at a trial or that may be helpful for future settlement purposes, whether or not the settlement occurs in a bankruptcy or outside of the bankruptcy. We recognize and acknowledge how significant your injuries are. Hearing loss, tinnitus have huge impacts on individuals. We've represented at trial many individuals like yourselves whose lives have been turned upside down because their hearing issues are very difficult for them, or their tinnitus is so bad that they really socially isolate themselves. So we hear you. We're here for you. I think I speak for everybody on the panel that we are very proud to represent our military in this litigation. It has been really the highlight of my career, and it's the proudest work that I'll probably ever do. So hang in there, stay with us, be patient, and we will continue to provide you with updates as soon as we can. And of course, if you have any questions, we've been trying to answer questions sort of feverishly, in the Q&A section, and we'll continue to do that. But if we don't get to your answers, we apologize, or your questions, we apologize for that.
Maybe, Dan, this is an opportunity for us to try to answer some of these so that everybody can hear the answers. I've been responding to a lot of folks. Jen, Dan, and Brad have been typing in as well. Some of the questions are really duplicative, and so a lot of you have the same questions. So what's the end game from a time standpoint? When can we expect resolution? It's a question that clients ask us all the time, and we try to not give an answer that is one where we're going to create an expectation and then not be able to meet that expectation. I've been typing to everybody that we hope, well, first, the bankruptcy will affect, if it does stick as to 3M, it will affect our proceeding forward. It will, affect a suspension or what we call a stay of the litigation. And so all of the momentum we have will be sort of like the trains, brakes are pulled and we screech on the track. And then there'll be a different separate track that we're going to go down. It's a parallel track in the bankruptcy court. The bankruptcy court, by the way, is not the end of the line, because a lot of product liability cases settle, and they settle where compensation is paid and the compensation is not bad through that administrative process, because the bankruptcy has to be funded. The irony here is 3M, AWKO doesn't have any money. 3M is going to have to fund the bankruptcy. They've offered to put in $1.2 billion, which frankly is a far cry from enough. If you think about 200,000 plus folks, that math ain't going to cut it. So, and if the amount they ultimately put in the bankruptcy that ultimately is written up in quote unquote the plan, if that plan is not approved by 75% of the creditors, it will not be approved. And so there is a negotiation to be had if we get stuck in bankruptcy. However, right now, we believe that bankruptcy is a sham. We believe on the 18th, we have a good basis to, and some reasonable chance of likelihood to kick the bankruptcy, and at least have the bankruptcy only apply to AWKO and not 3M, so we can proceed with litigation against 3M. So that's one angle, which is continue on the litigation track. Frankly, there was a bellwether, a 17th trial that's set in October. So if we're back on, and I know Judge Rogers wants to try that case, we want to try that case. And so we hope that next, as we're doing these town halls, which we're going to be doing often, we get close to that October timeframe, that will not just be talking about this bankruptcy relating to AWKO, but also the 3M trial that's underway, and maybe Jen and Brad and Dan will be lead and co-lead counsel on that. So the time frame, I've been actually typing to folks that we hope within 6 to 12 months there's going to be an offer in whether it's in litigation, further litigation against 3M, where we're basically separating them by a wedge, and or through a bankruptcy. The bankruptcy process that would ultimately end in a plan that could be voted upon, probably is in 6 months, probably closer to 12 months or beyond that. But mass torts, your case is not a class action. I see another question here. Your case is not a class action. Your case is your case. They are coordinated and consolidated for judicial efficiency purposes in Judge Rogers' court, right? Well, in the bankruptcy setting, you are a creditor, a personal injury creditor, and you have your own claim. So there would, in both instances, be a process where the claims are valued and an amount of money apportioned and offered to pay you that is consistent with the objective facts of your case, right? If you have audiograms that show hearing loss, if you've got tinnitus that's in the medical record, if you've got both, if you've got hearing aids that have been prescribed to you, there'll be some objective criteria that one of those two different avenues will have the administration of a settlement includes by definition the valuation of people's case using objective criteria. So that's and I'm hopeful that come 6 to 12 months we're going to be within that window. What's another either Brad, Jen, or Dan? What other questions are you seeing that you'd like to answer?
I think one question was, what is a realistic timeline for total resolution? And I think the best answer is it's hard to say. Every case is a little bit different. It's also difficult to say how long it will be in light of the current bankruptcy situation. I think, though, that in a typical setting, in a typical bankruptcy setting, I think it would be least 2 years from approval of the bankruptcy, maybe more. And in a, from a litigation standpoint, if we're able to defeat the bankruptcy, then I would suspect it'd be probably 1 to 2 years.
Well, we'll do an over/under bet, and I hope I'm right and you're wrong, Dan. But that's probably not a bet I'd want to take. And I apologize. Somebody was telling me they couldn't hear me very well. Or I have my mic stationed differently now.
Hey, Doug, just sorry. One of the questions we're getting repeatedly is how can we get information on our specific cases? I know we wanted to talk about the fact that we can't really talk about your individual cases in this setting. It's not really feasible to answer everyone's individual questions about their injuries or their specific records.
Yeah.
We are sending a follow-up communication that'll allow you to schedule an appointment with an individual in our office so you can have that discussion about, do you have all of my records? Is there anything missing? Is there, a positive and negative with my specific case?
Great.
Sort of thing.
Great, Donna, can you provide us a little bit more information and show us the last slide that has also the email address and telephone number? I'd like to have that be front and center so folks can write that down, because we want to take emails from you, want to take calls from you. And what Jen was just talking about is a scheduler so that we can actually schedule calls to the extent that we need attorney outreach. Okay, so let's leave that screen up for a little while because go ahead.
Yeah, sorry, Doug, I did not mean to speak over you. So as that is on the screen, I've seen a couple of questions about, there's some repetition within the outreach that our firm is doing with you. And yeah, I kind of touched on it earlier, but I really do apologize for that. We all do. But these deadlines and there's a lot going on. There's a lot happening fast, and we just want to be sure that we don't miss anything. So if you get an email that you responded to and you get another one, be patient with us. We're fighting hard. We've tried a lot of these cases, and these are, I see Jen laughing. These cases these trials are, 20+ hour days for weeks and weeks at a time. We're working hard and trying our best for you. Just be patient with us. You may get multiple requests for the same thing. You may have provided it and you get requests again. And some people on this call may disagree with me a little bit, but send it again. If things can be missed, we hope they don't, but it's better safe than sorry for us, because 3M is gambling and betting that soldiers like yourselves are not going to stay engaged and active and respond. And they've gotten a lot of cases dismissed for soldiers who have not responded and have not stayed engaged. And the courts had no choice but to do that. So just stay patient with us. Stay with us here. We're working with you. We're working for you. And we want at the end of this, 3M to be responsible for what they did to you. Jen or Dan, any other questions you see that we need to address?
Just scrolling through them right now. There was a question, I think maybe we should just touch on live for a second, Brad, about the successful trials versus the unsuccessful.
Yeah.
One of the reasons that we do reach out as often as we do for information, and I realize that there's a lot of duplicativeness, and sometimes you've already turned it in, or we think we're supposed to have it. That part of what we're looking at is that the individual issues with the people who were not successful is something that we can tell fairly easily from the records that we're asking for. And that is why we're reaching out to try to make sure that we can confirm what your noise exposure was at the time your hearing shifted. That we're reaching out to confirm that we know every duty station you had, so that there's not something that could come back up later. The individual cases that weren't as successful had concerns. They had conductive hearing loss as a child due to ear infections. They had a shift in their hearing during a time frame when they weren't actually around any noise even in the military. Those are the types of things that we were trying to identify easily through the types of questions we're asking and the follow-up information.
Yeah, so the cases, it's a very good question. So the cases that we've won, we found a path to get there. through there's general liability, which means what the company did and their conduct and their failure to test and their failure to properly vet and make sure this is a good and safe product before they ever sold it to the military. And then there's the case specific part, which is the specific medical records and other information for each soldier. So the ones that have not been successful have all been because of what we call case specific reasons, meaning there was hearing loss documented and significant before they ever got the combat arms earplug, or there was some other medical reason or some other medical explanation that 3M was able to use to confuse jurors on. We've been very successful, and the cases our firm has led, we've been very successful by and large anyway, but the ones that even have been lost, the jurors after the fact have been very displeased and mad and upset with 3M and what they did. It's just in those cases, they found that the conduct did not cause the tinnitus or ringing in the ears or hearing loss. So that's really the difference that we've seen. And that's why the devil's in the detail on these cases. And if any of you on here have been through the process, through the WAVE process, or you've gone through the expert witness development and all that, you know what we're talking about. There's so much work goes into every medical record, and you guys know how extensive and big and large your military file is. So to go through all those records and find every noise exposure and try to get the range exposure correct, because this earplug is horrible on the range, it doesn't work. And to try to figure out, they'll blame IEDs. They'll say, oh, well, they had an IED here, or they were wearing a foamy there. So for us to parse and go through and shoot the gap and look under every stone to prove these cases, all this information matters so much for those cases that get individually worked up and tried. And ultimately, we're hopeful those are the ones that are going to provide the foundation for a resolution that keeps a lot of you out of that process. The bankruptcy, we're not happy with what they've done and how they did it with the bankruptcy. 3M is trying to bankrupt a near defunct or defunct entity and get the benefit of that and pay you less money. It may work. Bankruptcy courts are weird. It's worked so far for Johnson & Johnson with their talc litigation. And, we've got the best bankruptcy lawyers in the country. We're fighting hard to keep that from happening. But, big corporations like 3M take advantage of loopholes and rules. And that's what they're doing right now. But just stay patient, stay with us, know we've got your back, and help us help you when we ask.
I'm seeing a question here. Thank you, Brad.
We just lost, you're on mute, Doug.
Okay, how's that?
That's good.
All right. So I see a question here about the $9.1 million settlement that was paid to the DoD and how that affects people's case. And it is confusing. Some of you may not know what I'm about to talk about, but before this litigation commenced, before Judge Rogers here in Pensacola, is what we call an MDL. There was an investigation that was done by the Army Criminal Investigative Division. And then ultimately there was a whistleblower case that was filed by Moldex. And that was, the DOJ intervened in that case on behalf of the DoD. The result was a settlement of $9.1 million. That $9.1 million is a slap on the wrist based on, in comparison to how much they made selling the product over those 15 to 16 years. But none of that money goes to our soldiers and Marines or any of the service members that were in any branch. And so sometimes folks are a little bit confused about that prior settlement and how it affects his or her case. It doesn't affect your case in any event, in any way. What it did do, though, is it provided information to a federal court in South Carolina that was running the Ketan case, the whistleblower case, and that court facilitated that settlement of $9.1 million. And then that court unsealed the docket, and we started to get, and the DOJ did a press release. We started getting, we were in the cradle of Navy aviation with the Blue Angels here and so forth. We started getting here a lot of Navy and a lot of Special Forces folks calling us and coming down. We've got a lot of clients who are veterans that were not related to the 3M case at the time, and started looking into it. And that was how we got involved in our investigation of this case was that moment the DOJ press release came out, and we started to get calls, and some folks came in the door and said, what in the world's going on here? I used that plug. So in any event, that doesn't have any effect on your case. It was just sort of historically the sort of the preceding trigger that got us involved. Let's see.
Hey, Doug, I saw another question that's been repeated a couple of times. It's what happens, Dan mentioned pictures and everything. Sorry, my phone's falling. What happens if we don't have pictures? The vast majority of you are not going to have pictures of these earplugs in your ears. The vast majority of you are not going to have the actual earplugs themselves. As you know, you've serviced out and you've returned a lot of things and they get lost. It's okay. In fact, of the cases, I was lead counsel on 2 trials. In neither trial did our client have pictures of the earplugs in their ears, and in neither trial did we have the earplugs in possession when the lawsuit was initiated. That's okay. If you have it, please keep it. If you have the plugs, keep them. If you have pictures, keep them. If you might have pictures, take the time to roll back through your hard drive, your phone, your colleagues who might have pictures of you. I mean, if we can have pictures of these plugs in your ears, that's great evidence, but it's not required. These are so unique. Like Doug mentioned, some people call them the bumblebees. They're the 2-sided ones. There's never been one before. There's never been one since. And I'm going to go further. There will never be another double-ended earplug like this ever. It was a terrible idea that never worked. And there hasn't been one. So they're so unique. That's why a lot of people like you guys remember having used them, because it was way different than anything else you had seen. So your case will not be dismissed. It's not the end of the world. Look, try to preserve what you have. If you find it, that's super. But if you don't have the plugs or a picture, you're going to be in the vast majority of your colleagues in this litigation. We're kind of looking now for other questions that have been repeated. We're going to try to get to all these questions. We're looking for others that have been repeated to be able to answer and not waste you guys' time on the call.
I think I saw a couple of questions. There may be a couple of people who use the combat arms earplugs as civilians, and you're in the same boat when it comes to the bankruptcy issues. Are you guys frozen? Okay. Same boat when it comes to bankruptcy issues. Still need to preserve your evidence, and your case is not being treated any differently.
Yeah. And so one thing, going back to the DD 214, and there are other equivalent documents, and I will admit that I don't know which branches, maybe Donna can help us, but which branches these relate to and so forth. But there's the NGB 22, the DD 256, the DD 257. The court has considered those to be equivalents to the DD 214. It is possible that the bankruptcy court, Judge Rogers was requiring our clients to produce those. And that was largely because she was finding that some of the bellwether trial selections were actually getting dismissed because the people didn't want to go to trial in their own individual case. And she sort of felt like, is there engagement with these active clients? Let's get them all to produce their DD 214s. And the defendants were asking for it so that they could identify their date of entry and their date of discharge and where they were and so forth. So the DD 214 became this big thing, right, in the MDL litigation here in Pensacola. But it's quite possible and probable that the bankruptcy administrator, if it goes that route, would also require some level of evidence that you were subject to, whether you might, listening in, you may be a contractor only and we're not actually in the military. But for the military folks that may have some indication, indices, evidence of being in the military. And so that's the form that's sort of like your driver's license, right? You leave with that form. It's an important form. And so everyone should have it. If for whatever reason you might not have it, there's a process, a pretty easy process to get it. And we've got a bunch of veterans that work here at the office that help our veteran clients obtain it. Donna, if you know a bit about that, you can certainly speak to it. But the email address, the telephone number that we want to flash up again, we invite you to definitely call us and email us because we can help you get that DD 214 or the equivalent documents. Donna, do you want to just take 1 second to provide us information that you have knowledge of on that?
While we're waiting on Donna, she can jump in in a second. Some people have asked what's going on with these verdicts. There've been some big verdicts. There's been press on some big verdicts. What's going on with them? And I'm going to tell you what's going on with them. 3M is appealing and fighting every one of them. They have not one soldier in this litigation, airman, soldier, anybody has been paid a nickel for their case. You see some things online that are reported, oh, 3M settlement, 3M this, 3M that. That's probably what prompted some of the $9.1 million questions with the government. Nobody, when I say nobody, I mean not one soldier has been paid a nickel. Not one service member has been paid a nickel for their case yet. We've gotten some very good verdicts. We've been again fortunate to be successful. They are fighting post-trial motions. They're up on appeal. One of the big issues on appeal is what's called the government contractor defense. It gets complex. I don't want to get in the weeds of it, but 3M claims that as a government contractor, that the Army was involved in the design of this plug at some level, and because of that, they are immune from liability. We feel very good about our position on it, but that's really the one, in addition to this bankruptcy where they're trying to minimize their exposure, the government contractor defense is their get out of jail free card on the appellate level that they could end up not owing any of you service members any money. We feel very good about our position there. We think they're wrong, but they are fighting at the trial level. They're fighting on the cases that have been activated level. They're fighting through bankruptcy. They're doing every damn thing they can do to avoid paying any of you people any reasonable money and delay it as much as they can. And our foot's on the gas through trials, our foot's on the gas through this bankruptcy to try to expedite those processes. But I've said it 10 times. Last time I'm going to say it. Stay with us, work with us. We're doing our best to do our best for you and get the best recovery we can for you under the facts and circumstances of everything as quickly as possible. Nothing in this business happens as fast as we want. We wish we'd get a verdict and they would just pay. That's not how that works. And they're going to exhaust every remedy possible to save money and to delay paying, because if they delay paying, they get to hold on to the money longer and they get to make money with it. And that's common sense. But we're doing all we can, I promise.
Okay, well, I do hope this has been helpful. We're about 7 minutes to the end here. Donna's flashing up a screen that is going to provide you some information on getting your DD 214. Again, we can help, but it's a process where we have so many clients that still don't have them to us. We hope folks will reach out on their own behalf. But Donna, do you want to weigh in here?
Yeah, so they can go to eBenefits or millconnect.com and you can download your DD 214. It takes about 2 minutes of your time to create an account and select the documents that you want, and then you'll get an email back saying these documents are ready for download. Then you can download your DD 214 and email it over to us. It's a very simple process, but we can walk you through it if you need assistance.
Okay, great. Well, we can. I tell you what, we'll probably do is we've got another 6 minutes. We're gonna type up some answers to as many of these questions as we can. And if folks have things to talk about and so forth, I'm gonna try to answer these questions. Donna's gonna be able to pull down unanswered questions. We should be able to email you all answers to your questions. I apologize if you don't get it immediately. Donna, how many unanswered, are you able to tell us how many unanswered questions we're sitting on?
So we have 235 open answers at this time.
Okay.
So I've seen a couple of questions about settlement and.
Sorry about that, Dan. Go again.
Sorry.
Okay.
Dan.
No problem. So I've seen a number of questions about settlement, value of settlement, how will claimants be treated, and whether or not you have to try a case to get a settlement. And so maybe we could spend a little bit of time, although it may be premature to talk about settlement at this stage. You know, I think we could provide some information on that. So this isn't, as you've heard, this isn't a class action. It's not a type of case where you receive, you know, in the future, some coupon that you can use. You know, this is a personal injury action brought on on behalf of a lot of people. So don't expect like a coupon settlement, number one. Number two, your case doesn't have to be a case that gets tried in order for you to resolve your case with the defendant. So if your case doesn't get selected for trial, that's okay. You know, there are 230,000 plus cases pending, and it would take us, you know, decades and decades and decades to try every one of these cases, and still wouldn't be able to do it in my lifetime, probably. So settlements, you know, trials happen in mass torts sort of as test cases, bellwether cases, bellwether trials. And they help both sides to understand the strengths and weaknesses of our cases, and also help us a little bit with the value of cases. And so that's what sort of the trials have helped us with, is understanding the strengths and weaknesses of our case. And you know, your case will be, you know, assuming there's a settlement in the future, your case will be evaluated based on your injuries. Anybody else want to add anything on that topic?
No, but I wanted to answer another question that was sort of an apology. We've been using the word soldiers very loosely, and I know Marines don't like to be called soldiers. Marines are Marines, but we also have airmen and sailors and other, well, members of all branches. So if we've been using the term soldiers loosely, we do apologize. Here's a not a question, but a statement that the earplugs are the worst plugs ever manufactured. I agree. And we, you know, it was just really a crazy that this product remained on the approved product list, you know, for those 15 years. Meanwhile, other products like the Surefire, I don't know if you guys know the Surefire Sonic Defender, that has the concha lock and it's got kind of a curved, that's a product that I like. The battle plug is another product. So there's all sorts of products on the market, and we're available, technologies that were available when you all were using the plugs. And of course, if you had known the difference between this plug and the other plugs in terms of the defective design of the Combat Arms version 2, you never would have used it. So it's a great liability story. 3M acted error and 3M acted very, very badly. It's the most compelling case that I've, just like parroting what Dan said, that I've ever worked on. This is an amazing group. The demographic working for our veterans and current active service members is an amazing, you all are an amazing client. We've done a lot of pharmaceutical and medical device litigation for the last 20, 25 years, but this is the proudest I've ever been being a lawyer and representing you all. So looks like we're about to turn into pumpkins, guys. So everybody, thank you so much for attending. This is double the attendance we had last town hall. If you'd like to attend a future town hall, certainly may. That's going to be available to you. If you have questions that were unanswered or we don't email you immediately, come on back on and ask questions. Maybe there's a different speaker that provides a little bit of a different flavor to the subject matter. But again, thank you from myself. And anybody else have any parting words?
No, Doug, again, just thanks for being here. Thanks for participating. And we'll keep working.
Yep. And if we didn't get to your answer, we apologize. It's there's a lot of you on here, so we tried our best.
Okay. Thanks, everybody.